SJC-11977, Caitlin Goodwin v. Lee Public Schools.
Mr. Schneiderman, good morning. Good afternoon. Good afternoon, I'm sorry to say.
Good afternoon, yes. I was watching the clock.
Why don't you proceed?
Thank you. Good afternoon. May it please the court. I am Joseph Schneiderman. I rise for the plaintiff, Caitlin Goodwin. The question before the court is this: has Ms. Goodwin carried her threshold burden to assert that when she was 17, the Lee High School unlawfully suspended her for conduct occurring off campus? For 3 reasons, she has carried her burden, and the complaint should be reinstated. First, the remedy of damages exists in tandem to the remedy of reinstatement, and seeking damages is not contingent upon having obtained review of the suspension.
Is it the fact that Chapter 76, Section 16, do I have that correct?
That is absolutely correct, Your Honor.
The fact that you say it doesn't matter that there wasn't a claim for it in the complaint.
That's also correct, Your Honor.
And
I'm sorry.
Well, that's because?
That's because this court always looks to the substance of the complaint. Although the complaint is titled violation of Chapter 71, Section 37H and 1/2, the substance of the complaint is indeed an unlawful exclusion because Ms. Goodwin was suspended in violation of the mandatory and sequential two-prong inquiry that Section 37H and 1/2 imposes on a principal.
And I just don't remember this. Was the relief sought in the complaint damages?
Yes, it was, Your Honor. I believe at the last paragraph of the complaint, which is at page 7 of the record appendix.
It does. So you would say implicit in that is it would have had to have been under Section 16.
That's absolutely correct, Your Honor. The complaint is for damages, and the substance of the complaint is what matters.
Because you couldn't get damages under 37 and a half.
Yeah.
That is absolutely correct, Justice Lank. We haven't briefed the question of if 37H and 1/2 creates a freestanding private right of action, but you cannot obtain damages that way. The most you could obtain is reinstatement by the superintendent, or indeed reinstatement by a court. So,
but your action is for a violation of 37H and a half.
That's correct.
That's the underlying action. You say that was violated, and therefore we should get damages.
That's correct, Your Honor. That is the underlying point. The unlawful exclusion, and a lot of this hinges on the word unlawful in Chapter 76, Section 16, is the violation of Chapter 71, Section 37H and 1/2 because no felony complaint issued against Ms. Goodwin.
Let me ask you, if you prevail and you go to trial, I'm wondering whether or not your client's failure to avail herself of the invitation to have a hearing and the question of whether or not she would have ever gone back to school anyway, that I take it is a question of mitigation of damages and not a question of exhaustion of remedies.
That is precisely correct, Your Honor. It would be a question of damages as to whether or not Ms. Goodwin perhaps should have returned to Lee High School, or her failure to return or to seek any review mitigates her damages. It should not be, as Your Honor is suggesting, a bar to her maintaining her action for unlawful exclusion.
But I mean, she had the right to appeal under the administrative procedures. She didn't. Now, maybe she didn't want to appeal because, Lord knows, they were deciding whether to charge her with a felony or not. Yeah. And maybe she didn't want to put it squarely on the table. And she was maybe very fortunate to be charged with misdemeanors in this case. So why should the school pay a price for that? That your client didn't want to appeal and raise the issue?
Justice Cordy, I have 2 responses. The first response is that the mandatory prongs of Section 37H and 1/2 simply never existed. No felony complaint ever did issue. That was based on, for whatever reason, the record is sketchy about this, misinformation to Principal Burke, because apparently the Lee Police issued some sort of a press release. My second response, though, is assuming that Your Honor is correct, that there is some requirement of exhaustion. Exhaustion in this case would be futile. Now,
Why? You make the point. She appeals and she says, there's no felony complaint issued. There may be felony charges under investigation, but they haven't issued it, therefore you can't suspend me. Why would that have been futile? It's like a perfectly good argument.
Did they not already know that?
I'm sorry.
Did they not already know that as of the time they sent the letter in January, that there was no felony complaint that had issued?
It seemed to be, from the context of the letter, the way it's written, that the way it's written is not that she had been charged, but that something in the future might occur. So
Isn't part of your argument that section 37H1/2 isn't triggered, whatever, until it has issued? So the fact that there might be a felony complaint issued or a juvenile complaint issued doesn't trigger the statutes. You can't suspend until the school department has the felony complaint in its hand.
Justice Botsford, that is absolutely correct, and that dovetails back to Justice Duffley's question, which is the felony complaint must have issued from the court. It is not the school's province to make a determination that a felony complaint has issued, and that further ties back to the futility doctrine.
The mistake of fact. If you read this letter, this is because of the criminal proceedings as a result of the issuance of criminal complaints by the Lee police against her for weapons charges, blah, blah, blah. You're saying, well, no, they actually hadn't issued that complaint yet. Why isn't that a mistake of fact? Is it exactly the kind of thing that would be appropriate in an administrative appeal?
Justice Cordy, as the amici emphasized, and indeed as was emphasized earlier in my response to Justice Botsford, Section 37H1/2 never should have applied to this scenario because the legislature set a definite standard by using the terms criminal complaint charging felony.
And so the hearing, as I understand your argument, you can't have an hearing when there's an illegal basis for the imposition. That's not what it's about. The hearing is all about, you shouldn't be suspending me or expelling me. This isn't serious enough. You should do this, that, or the other thing, even though this has issued. Is that essentially what you're saying?
That's correct.
Okay. But let me go to the next question, and maybe you were going to go there anyway. But under Section 16, they suggest there that there ought to be a written statement of reasons, and thereafter you get to proceed.
That's correct.
What do you do about that?
Sorry?
Well, I'm asking, I'm sorry, I interrupted.
Is your argument there that, well, one, this is a pretty old statute. I mean, it goes way, the premise goes way back to 1800s, most recently 1971, and it's only after that we get the current situation. Is your argument that it wasn't necessary? Well, why isn't it necessary? Because she did it already? Because the statute doesn't contemplate the subsequent statute, which has it by itself already the furnishing of reasons, and they were furnished, so that if you dovetail 37H1/2 with this one, you've got the reasons.
Justice Duffley, that is correct. In any event, reasons were, Ms. Goodwin received reasons for her suspension, and that should suffice to meet her burden under Section 16, regardless of how Section 16 is written. The grammar of Section 16 commands the school to supply them if they are requested, and in this case, in any event, they were indeed received.
If I can go back to poor Justice Cordy's unanswered question of why it was futile.
Certainly.
He asks, why is it futile when you can go to the superintendent and say, Superintendent, you can't do this until a felony complaint has issued. It hasn't. You're wrong. I win. Why is it futile?
Mr. Chief Justice, I share your and Justice Cordy's concern that one may not deem a remedy futile by fiat. However, in this case, the superintendent's December 21st letter said, although Ms. Goodwin has not perhaps been charged yet, I still believe that she should be suspended, and I'm going to ignore this statutory standard. The defendants are correct that that initial suspension was not pursuant to Section 37H1/2, but the superintendent does reference the 5-day appeal period in that same letter. And I think what is important about all of this is that the principal and the superintendent ignored who may issue a felony complaint, and that is a court.
And doesn't it indicate also that they were aware that a felony complaint had not been issued?
Yes, Your Honor, I think that's a very fair inference.
Where does that, where does that come from? Where does that come from?
The letter.
That the court knew back in January that in fact there wasn't a felony complaint?
I'm sorry, Your Honor.
You say the school knew there was no felony complaint back in January. Didn't you just say that?
Perhaps direct knowledge is an overstatement. I apologize if that was an overstatement, Your Honor. But I think what is clear here is that the statutory standard, which is plain and unambiguous in 37H and 1/2, simply never existed. And for whatever reason, the school said, we are going to suspend Ms. Goodwin regardless of this statutory standard.
Well, now in April, after complaints did issue, and she was fortunate enough not to have a felony complaint issued, her counsel said, now we'd like our hearing. Okay? So they did request a hearing under 37 and a half. Right?
That's correct. Attorney Jacob did request a hearing.
Right, and and I take it there was a hearing. And you could have gotten the same hearing back in January.
Your Honor, as far as I know, there was not actually a hearing after April 25th. The record indicates that there was some sort of a meeting on May 2nd.
And they said she could come back, and she said, no way in hell am I coming back. Am I wrong?
Your Honor, that is correct in the record. However, to the extent that that is an issue in the record, or as Justice Spina drove at earlier, that this is, there is some dispute about how and when Ms. Goodwin came back or her damages, that is not the proper province for this issue of the motion to dismiss for failure to state a claim.
What statutes or procedures govern, forget the felony, but you've got a student who is misbehaving badly, let's just say, and the school suspends, and is there a statute that then governs what happens when the school suspends in terms of the due process rights of the student to challenge that?
Justice Botsford, General Laws, Chapter 71, Section 37H governs the type of misbehavior that you're driving at. Subsequent to when this case occurred, General Laws, Chapter 71, Section 37H and 3/4 was enacted that deals with suspensions not arising for a felony complaint or not otherwise covered by 37H. To Your Honor's more specific question about further redress, this actually ties into our point that exhaustion would have been futile. Review of a suspension of this sort occurs on an expedited basis. One has 5 days to seek review from the superintendent. One thereafter has 60 days to seek certiorari review under Chapter 249, Section 4.
Right, but so you're saying either 37H or 37H and 3/4 governs when a child is suspended independent of any felony or misdemeanor. Is that
That's
right?
correct. It would govern, I'm sorry, I may have overstated that. It would govern when someone is not suspended because a felony complaint
But
is issued.
wasn't the plaintiff in this case suspended for a week before 37H1/2 was invoked?
That's correct.
Under what statutory authorization?
That was pursuant to the student handbook, which is promulgated pursuant to 37H, no fractions attached. And I'm not certain, though, if there is further statutory authority for the specific provision of the handbook dealing with a reported violation of criminal law.
Oh, is there a cap on the length of suspension that she could have received instead of the 1-week suspension?
Under 37.
Under
30 days.
37H?
Is there a 30-day cap?
I believe so, Your Honor. I haven't looked at 37H recently, but I believe there may be a cap, yes.
And is there, I don't, do you have 37H in your brief?
It's not under 37H. Under the
I have
handbook.
37H and 1/2 handy. I don't have 37H.
Okay, so but my question is, if 37H applies, does it have the same kind of provisions as 37H1/2? That is, you go to the principal, you go to the superintendent, you can bring a certiorari. Does it have that same kind of procedural stuff?
I believe that is correct. I believe this court's decision in Doe versus Weston deals with a 37H suspension as
But why
opposed.
wouldn't that, so if you're right, that 37H1/2 doesn't apply here because yeah, it doesn't apply here. Why wouldn't then 37H apply, and would there be an exhaustion argument to be made there? Do you see what I'm saying? In other
I
words, they
do, yes.
suspended, they can't, accepting your view, they cannot suspend under 37H and a half, but they have suspended, and you're challenging it.
Justice Botsford, I believe I'm still left with the problem, and I share the court's concern that one cannot deem a remedy inadequate by fiat, but that the remedy occurs on such an expedited and rushed basis that the damage is done. Indeed, I believe the language of all of these statutes reads, the school's decision shall be final, and because the statutes do not reference 30A or some other form of review, the default is indeed certiorari. One would need a lawyer to make sense of certiorari, and at all pertinent times in the record of this case, Ms. Goodwin was unrepresented by counsel until Attorney Jacob entered the picture. I see my red light is on.
Great, thank you.
Thank you.
Good afternoon. May it please the court, my name is David Monastersky. I represent the Lee Public Schools, the town of Lee, and Jason McCandless in this matter. First off, Your Honor, the plaintiff brought this claim as a violation of 37H and a half. They framed this as saying is the school system violated that statute when it suspended her without a felony charge being issued.
In the sense that it doesn't apply to her at all.
Well, it was, that was, the suspension in January was issued under that statute, and it appears to have been a mistake in fact, because the school
Or a
was-
mistake about the law. I mean, where was the mistake in fact? I
The
mean,
mistake in fact was they thought a felony charge had issued.
Oh, really? I think that
You
on
actually-
December
Weren't they
21, 2011, from the superintendent to the mother, he says, "We're keeping Caitlin out of school until the legal matter is clarified. While she's perhaps not been charged yet, her presence in school creates opportunity for her to be distracted." So they had reason to believe she had not been she had not been charged with a felony.
Which letter are we talking about?
December 21,
December
21.
2011.
21, but
That's,
the
that's,
suspension letter is
that's the
December
first
26.
suspension.
So they
that
knew
was
at
not
the
under
time,
statute.
and they never confirmed before actually doing it under the statute that she had been
Well, no.
indicted.
Then the
I mean,
principal,
I'm sorry, that a complaint issued.
the principal's letter of suspension, because it's the principal that suspends, January 6, 2012. I'm invoking my right to suspend you during the duration of the proceedings as a result of the issuance of criminal complaints.
Which the superintendent had reason to doubt.
Well, no, that's a prior letter. So
Well,
this is
you know-
January.
But they're thinking that she's been in, that she has had the complaint issued against her in December.
Excuse me, Your Honor?
Thinking that she had the complaint, or that it's about to issue in December.
Yes. And then in January, the principal, under the belief that the criminal charges had been issued, suspends her specifically under that statute.
But
Isn't that a question of fact?
Why isn't that a question?
Actual,
Why isn't that a question of law? And shouldn't, if two people are looking at this statute, don't we expect the superintendent to figure out whether a felony complaint has issued or not?
well, it only gets to the superintendent if there's an
Well,
appeal
the
from
principal, the school official.
The school official,
I mean, why does the school, I'll ask it rather baldly. Why does the school official get off the hook because he or she has not bothered to figure out whether a complaint issued or not, and whether it's a felony complaint?
they're not off the hook. There's a right of appeal to the superintendent, and then the
No, that the statute doesn't apply, because the statute says you need a felony complaint.
But if you're suspended under that
The issue is,
provision,
because in this lawsuit, the plaintiff has framed the issue as saying is that she was unlawfully excluded and in violation of that statute. And she's
That's
claiming
right.
a violation of that statute. So if you're claiming a violation of that statute, you have to exhaust the remedy that's set forth in that statute.
Oh, so if you,
Because
does that mean that an action under Section 16 can never be brought if the school has made a mistake?
under that statute, no.
So let's say, let's say they did everything you say that they're supposed to do, exhausted their remedies, appeal to the superintendent. The superintendent says, go pound sand. It doesn't matter, we think that, just thinking that there would be a felony complaint was enough. And so we're not going to change a thing. And then you have the other appeal, the administrative appeal, and then they lose. So you're saying all that happens by doing that is that she gets back into school. It has nothing to do with how she's to be compensated for what damage has been done to her in the interim.
No, if she exhausts that process, then and if she gets put back in school, she can then bring an action for damages after she exhausts her administrative remedy, which would include the certiorari if the
So
superintendent
that could
decides
take
that she
a
shouldn't.
long time.
And then you get to
Actually-
appeal the certiorari. So it's about 3 years later, you get your damages?
And then you can get some damages, because then you can bring a complaint under Section 16?
Yes. I mean, there's the issue of getting the kid back into school. And then if the kid who's determined to have been, should not have been suspended under the statute, which they're claiming in this case, she should not have been suspended under the statute. The complaint is specifically limited to specifically paragraphs 1, 16, and 22, repeatedly claiming that the district violated that statute when it suspended her.
Oh,
And if you're claiming a violation of a specific statute that has an administrative remedy, you have to exhaust that remedy before you proceed for
But
damages.
are you saying it would have made a huge difference if the complaint had been fashioned as a violation of Chapter 76, Section 16, and simply have declared that it was unlawful?
And the basis was that I was suspended under a statute that didn't apply to me.
It would not have made much of a difference in this case. The question is, would the first suspension in December, the 6-day suspension, because that was not done under the statute, but we still would have raised the fact is, the second suspension was under 37H1/2. You had to exhaust the remedy under that.
So it's
But
not
the thing is,
it's not the form of the complaint that's at issue here. It is whether or not, when the claim is that it was unlawful because of a violation of 37.5, whether or not you have to at least appeal to the superintendent.
and then take the certiorari if
Yeah,
you,
where do you get this?
there's,
Oh, the certiorari is not in the statute.
it's not in the statute, but it's, this, I mean, the statute that provides certiorari says if you don't have another avenue of review, and there's actually the Superior Court case that says if you
Wait a
don't succeed on the 37H1/2, you go under the
You
49.
certainly have a remedy, but I mean, but are you saying that under Chapter 76, Section 16, the finding of it being unlawful must precede the bringing of the complaint?
Excuse me,
Are you saying that to bring a complaint under Section 16, you must already have exhausted it and obtained a finding from the Superior Court that it was unlawful?
under,
As a-
if
as
the if the violation is for 37H1/2,
As a predicate?
as a predicate.
So
So-
you would have to then
Because,
bring a certiorari. If you were to fail to prevail before the superintendent, you would have to prevail on a certiorari action in order to then say, now I want my money under Section 16.
yes,
And I take it, you couldn't even do it then, because if you prevailed in Superior Court, the school could appeal, correct?
well, they could appeal, but the issue on the certiorari would be to get you back into school at that point in time, because it's not a damages action at that point in time. It's the action, it's an appeal from the wrongful suspension.
Yes, but-
You're
So
arguing.
there'd
to
never be a declaration that it was wrongful, right?
Excuse me?
There'd never be anything determining that it was unlawful.
Well, it would be a determination, the court would, there's two factors under the statute under your suspend. One is the issuance of the felony complaint, and the issue is that it has to be detrimental to the welfare of the school. So the court on the certiorari would be examining those two issues. First, is there the complaint? And secondly, did the superintendent abuse his?
You ever get to the
I mean,
second one?
isn't it likely that if there had been an appeal here,
Yes.
this would have been resolved in 5 days?
Within 5 days, had the plaintiff said, I want my appeal, within 3 days or within another.
Mother telephoned the superintendent and told him that she did not have a felony complaint issued against her daughter, that there was not a felony complaint issued against her daughter. Is that not so?
Not as of, that was not as of.
That was
the
in
type-
December.
That was in December.
So they
But the
knew in
fel-
December.
There is no complaint issued as of December.
And there's no complaint issued in January, and no complaint issued in March, no complaint.
But the principal was under the belief that a complaint had issued in
So
January.
that's not the predicate for a 37.5H1/2. It is that one has issued.
Yes, well, but that's an issue of that's a factual error. The principal may have been in error.
Why isn't that a predicate requirement before they go ahead with this? That they have to find out that there is a basis in the law to actually pursue this kind of action?
What's the basis?
That's
of
their
it?
requirement.
The
You
basis
don't
of-
just say any old thing and then say, let's see what pops back.
Well,
Maybe
they-
they'll
they
just
were
say,
un-
fine, they won't know the law. Hey, we'll get rid of her, she'll be gone all semester. By the time this rolls
Well,
around,
no,
we'll
actually,
be done.
it wouldn't be all semester. It'd be, the appeal period to the superintendent is over within 13 days. There's a 5-day period to, and these are calendar days. 5-day period to appeal. Their hearing has to be held expeditiously, and then an order, a ruling from the superintendent has to be issued. Those days all add up to 13 days. Had she filed an appeal to the superintendent and raised the issue that as of the suspension that it was issued from the principal in January, I have not been charged with a felony.
You're
So
s-
therefore, you can't suspend me under the
You're
statute.
assuming that she didn't already say that, and yet they did. So, I mean, in fact, she did say she's not charged, as this letter says, and they still went
What letter are we
ahead.
talking about? What letter are we talking about?
It's at RA 49.
Is this the December letter?
Yeah.
Oh, that,
yeah.
she wasn't,
This all
that wasn't,
predates.
I take it, the December letter was not under this statute.
The December letter was not under the statute. The
It's-
December letter was under the
That there
handbook.
was no charge of a felony was apparently made clear by December 21st. They didn't bother, apparently, to disabuse themselves that there subsequently then was new information. Somehow they acquired new information that there was a charge that was wrong, and so now it's a factual question is what you're saying. Here on December 21st, all I'm saying is they had information. She said, no, she hasn't been charged. And yet, within a month, or about a month, what happened to make the same school system come to the conclusion that even though they knew in December 21st there hadn't been one, now they're going to take the position that there has been one?
Because
What happened?
the principal was misinformed.
By looking at going to the police station and say, can you tell me what happened? Has she been charged yet?
I do not know how she came to that, to the conclusion that a charge had issued.
Certainly not from the mother or the child.
Well, you wouldn't ask the mother or the child if a charge is issued.
If the
If I
super,
can step back, I mean, this is a motion to dismiss. We're not here on issues of fact.
Right.
We're here only on the single question of whether or not legally there is an exhaustion requirement.
And that goes back to the issue of the way the plaintiff framed the complaint. The plaintiff framed this complaint as a violation of that statute. The plaintiff saying is, you suspended me under that statute when.
I get you made the argument. Let me ask another question. When was a Section 16 promulgated by the legislature? Which came first?
Section 16.
Yeah, well,
Section
that's
16 came
Well,
first.
the predecessors.
It was
statutes
in
to
the,
that
it was
go
in the
as-
19th century.
Very
as-
old,
as
18th
what is
century.
recognized. That goes way back in time.
Yeah.
And that's why it's important, you have to, 37H and a half, unlike 37H and 37H and 3/4, actually has the introductory language, notwithstanding the provisions of sections 84 and sections 16 and 17 of chapter 76. So it's saying, notwithstanding section 16, you can suspend for the issuance of a felony complaint if there's a determination that's detrimental.
That's right, but there's no felony complaint. Why isn't it the school department's, why isn't that a condition precedent to suspending, is that they've got a felony complaint?
It's one of the two factors under the statute that,
They need to have, and they didn't.
and they also need to have the detrimental to the welfare of the school. So that by saying there's two factual determinations under the statute that the school system has to make.
But here's the point. Whether it's detrimental or not is going to be involve judgment, whatever. There either is a felony complaint or there is not. And why is not that, why isn't that having a felony complaint issued a condition precedent to suspending under that statute? And if you don't have it, it is not lawful.
It's a condition, it is a condition precedent to suspend under the statute that you need that. But the problem also is you're
But you
dealing.
get around that by saying, oh, well, it was just a factual error. Why isn't that, why don't you have that? Why isn't it a condition precedent? You have to have it.
Because in a situation such as this, first of all, not every police department is cooperative with the school systems in the town to let them know when a minor has been charged and what's going on with the criminal charges of the minor. So therefore, the principal may not have all the necessary facts,
So
but
you
he's under
can't
the.
suspend until you do. Because it seems to me that
That's
the
what
law is
they
also
did, that's what they
pretty
did in
clear.
December, and she was under
Isn't
the
it
So
pretty
impression.
I take it if the principal went down to the juvenile court and said, I want to know if so and such a child has been charged with a criminal offense, do you think the juvenile court would give that information out?
No, there's only, it's only certain crimes that they have the obligation to inform the school system about. But that's why is this,
But isn't it the general principle under Section 84 that no student shall be suspended for conduct which is not connected with any school-sponsored activities? And 84 and a, I'm sorry, this 37H and a half is an exception to that. And that applies when there has been a felony complaint issued. It's an exception to the general rule.
saying notwithstanding.
Yes, notwithstanding
Notwithstanding
that.
the general rule,
That notwithstanding the general rule, you can suspend if there is a felony complaint.
yes.
It's an exception to the general rule that you may not suspend unless it has to do with school-related activities.
Yes.
Right.
So in that situation,
So in that exception, you actually have to have a felony complaint that has issued.
yes, and there was an error made by the principal in determining that a felony complaint had not issued at that point in time.
If in this case, after 20 days, after having sent the 37H and a half letter, there's no appeal under 37H and a half, and another 2 weeks goes by, and the principal learns that there is no criminal complaint, felony complaint that issues. The principal then says, oh my God, I made a mistake. You can come back to school. Kid comes back to school. Can the plaintiff bring an action under Section 16 for damages in those circumstances?
I would argue no, that they cannot bring action under Section 16 in tort, but there are other remedies.
But why couldn't they do it? Why
Because they
not?
didn't exhaust the remedy when it was.
But they've been exhausted. They waived the right.
The plaintiff waived, the plaintiff waived the right, or the school
The
system.
plaintiff waived the right.
So the plaintiff waived the right of exhausting that
Yeah.
remedy. So the remedy rests with the plaintiff, or the student in this case. So the student doesn't exhaust their remedy. They sit back and do nothing. And they're the one who is,
Aren't they entitled at least to damages for 5 days?
are they, for 5 days, well, in that case, you're saying for not taking the hearing?
Yeah.
I'd argue no, because they still have the exhaustion requirement, and this court has recognized when there's an administrative remedy, you have to exhaust it. And the situation you're saying is, well, let's say the situation where it's determined that it's not detrimental. Let's say the situation whereas there is an issuance of a criminal complaint for a felony, principal suspends, and then it comes back and the superintendent says, well, I don't believe that your attendance in the school will be detrimental to the welfare of the system. And so in that situation, you have a short suspension. The superintendent makes the decision that it's not detrimental. They're saying is that point in time, you're going to be entitled to damages because the superintendent disagrees with the principal, saying is that it's not detrimental. I mean, you have a suspension, but it's not. But it was determined to be inappropriate under the statute.
All right, well, thank you. Time
Thank
is
you,
up.
Your
Thank you.